Parties absent, appearances, please.
Hey, please, my lord.
Yes.
Okay, Rikefe. Appear for the claimant.
Yes.
Most respect to my lord. K.Y. Waje.
Yes.
Appears for the defendants.
Yes.
My lord. My lord.
Yes.
Matter is for adoption of final written addresses today.
Yes.
My girlfriend has an application to bring their address in out of time.
Yeah, you have a motion for extension of time to file your written address.
Yes, my lord.
Excuse me, I'm looking for the motion. It was filed on the 25th of March.
Yes, 2020, my lord. 2022, my lord.
Yes, Mr. Rikeke, what is your reaction?
We are not opposing the application.
Yes.
My lord, we apply to move our motion in terms.
Court application granted. Time is hereby enlarged within which the defendants may file the written address. They already filed and served. The address is deemed as properly filed and served.
As God pleases. We are most grateful, my lord.
Yes.
My lord, we have filed our address even before the grant of this application. We urge my lord to deem same as filed.
Okay. We apply to
Deem our address filed on 8 May 2022. Deem same as properly filed from today.
defense counsel, no objection.
None, my lord. None.
Application granted. The claimant's written address is deemed as properly filed and served.
As God pleases.
Yes, Ms. Wajid.
Yes, my lord. Our final address is dated the 24th day of March 2022.
Deemed filed today.
As the court pleases.
Yes.
My Lord, we adopt them as our oral argument in this matter and urge my Lord to uphold our dismiss claimant's case against the defendants.
Yes, Mr. Idigbe.
My Lord, the claimant's final written address is dated 16th May 2022.
Yes.
Along we adopt same as our final argument in this case. I will urge my Lord to grant the release of the claimant.
Thank you, sir.
As call, please.
Court case is adjourned to 06 October 2022 for judgment. 6th of October 2022 for judgment. Thank you.
I'm most grateful, my Lord.
Yes, the next case, please.
Case number 2, NICS/KD/18/2020 between Private Daniel Monday and Nigerian Army. My Lord, parties absent.
Parties absent, appearances. Appearances for the Daniel Monday case. Ms. Jehu, Ms. Nuhu. Mr. Irikefe and Ms. Waje, you have the permission of the court to leave the court. Yes, appearances for the Daniel Monday case.
My Lord, she's connected, but
probably she's mute.
She muted.
Yeah, she's on mute. Can you hear?
Maybe your registrar should call.
My Lord, J.K. Nuhu is appearing for the claimant. My Lord, I don't know if my Lord can hear me now.
Yes, I can hear you now. Thank you.
Okay, very well, my Lord. I'm very grateful.
Do we have a representation for the defendants? I've recorded you, Miss Nuhu. I'm waiting for the defendants now.
There is no representation.
No representation.
Hello, my Lord.
Yes.
My Lord.
Okay, the ruling now.
Yes, my Lord. As court pleases.
claimant commenced the present action by complaint and statement of facts filed on the 20th of March 2020, whereby he claimed reliefs against the defendant on allegation of unlawful dismissal of his appointment. While the action was pending, the defendant filed a notice of preliminary objection on the 12th of August 2020, challenging the jurisdiction of the court on the ground that the claimant's action is statute barred, having not been filed within 3 months from the date of the course of action pursuant to Section 2A of the Public Officers Protection Act. On the 2nd of December 2021, the Honorable Court dismissed the preliminary objection and held that the claimant's action is not caught by the provision of Section 2 of the Public Officers Protection Act, that is, the action is not statute barred. The instant application filed on the 23rd of March 2022 is praying the court for an order of stay of proceedings of those suits pending the hearing and determination of the interlocutory appeal against the said ruling.
Appearing in court, please.
I had given a careful consideration. I hope you can hear me.
Yes, my lord, I can hear, my lord.
Yeah, thank you. I had given a careful consideration to the totality of the written submissions canvassed by learned counsel on both sides with respect to the instant application. The factors the court will normally consider in granting or refusing an application of this nature are no longer recondite and are adequately captured by learned counsel on both sides. I need not restate them here. Suffice it to state, however, the stay of proceedings is a serious, grave, and fundamental interruption in the right that a party has to conduct its litigation in the trial on the basis of merits in its case. Consequently, the court's general practice is that a stay of proceedings should not be imposed unless the proceedings beyond reasonable doubt ought not to be allowed to continue. Where an application for stay of proceedings will unnecessarily delay and prolong proceedings, it will not be granted. See the cases of Cabo Hair Limited versus Inco Beverages Limited and Aregbeshola versus Oyinlola citation supplied. It is equally trite that a court has a discretionary power to exercise in the matter, and like every other discretionary power, it must exercise such power judicially and judiciously. In other words, the discretionary power must not be exercised in vacuum, but in relation to the existing facts of the particular case before the court. See the cases of Omar Brothers Nigeria Limited versus Kigo, Akilu versus Power number 2, Nika Fishing Company Limited versus Lavina Corporation, and Cabo Hair Limited, citations also applied. In granting the present application, the effect of which is to delay speedy hearing of the case, the court must be profoundly satisfied that there is indeed exceptional circumstance or circumstances flowing from the facts of the case that will sway its mind in the direction of altering the proceedings pending the final outcome of the appeal lodge. The question to be determined by this honorable court is whether the applicant has disclosed exceptional or special circumstance or circumstances to sway the mind of the court in its favor. This can only be found in the material facts before the court, and sufficient material or materials must be available before it can exercise its discretion. It is worthy of note that the applicant in paragraph 4, sub 1 of the affidavit in support of the application raised issue relating to or touching on the jurisdiction of the court, which issue, according to the learned counsel for the applicant, will finally dispose of the case. The deposition were, however, debunked by the claimant respondent in his counter affidavit filed on the 30th of March 2022. The respondent in paragraphs 3, 4, 5, and 6 deposed that the case has suffered undue delay by the applicant, that the present application is to further frustrate the hearing of the substantive suit, that the respondent who was dismissed from his appointment since 2015 will suffer greater inconvenience if this action is stayed and there are no exceptional circumstances to warrant the grant of the application. It is the submission of learned counsel for the applicant that the factors that constitute special and exceptional circumstances vary from case to case, and that the factors include: 1, where the ground or grounds of appeal raise question of jurisdiction of the trial court, and 2, where the interlocutory appeal, if successful, will put an end to the proceedings in the trial court. The cases of Doma versus Ugiri, Governor of Abia State, Sananadov versus Anawati and others, citations supplied were cited to portray his submission. It is equally tried and as rightly submitted by Learned Counsel for the applicant that where issue of jurisdiction is involved in a pending appeal, a court is bound to grant an application of stay of proceedings pending the determination of the appeal. Issue of jurisdiction must, however, not be raised by mere saying it of it or raising it. To put it differently, a court should not be swayed by the mere raising of jurisdiction to fold its hand or to simply for that reason grant stay of proceedings. It is always very important to draw a distinction between the mere raising of jurisdiction in an appeal and the real involvement of jurisdiction in the appeal. Jurisdiction is a matter of law handed out by either an enabling statute or the Constitution. Therefore, before granting stay of proceedings on issue of jurisdiction, a court faced with an application for stay must be fully satisfied and convinced that there is really a genuine issue of jurisdiction involved in the matter sought to be stayed. See the cases of Eze versus Okunlaji, the Federal Republic of Nigeria versus Abacha and others, citation supplied. Such other factors guiding the exercise of the discretion to grant or refuse the instance application as submitted by Learned Counsel for the respondent are the consideration of the competing rights of the parties, and 2, all the circumstances surrounding the litigation by parties. The cases of Until Gas Nigeria Limited versus Pan and African Bank Limited, Vashuani Trading Company Limited versus Savilak & Co, and Jadesimi versus Okotiebo were cited. These cases are apposite. In the instant application, the issue of jurisdiction raised by the applicant, that is the claimant's case, is statute barred pursuant to Section 2 of the Public Officers Protection Act, has been given judicial pronouncement in the recent case of National Revenue Mobilization Allocation and Fiscal Commission and 2 others versus Ajibola Johnson, 2019, 2 Nigeria Weekly Law Report, part 1656 at page 247. In my humble view, there is no shred of doubt that no genuine issue of jurisdiction was raised, and I consider the jurisdictional issue being raised as a mere camouflage to further delay the hearing of this instance case. I should restate the tried position of law that where the grant of a stay will unnecessarily delay the procedure, stay of proceedings will not be granted. In the final analysis, I am of the view that the applicant has not placed material facts before the court could consider the application. I therefore fail to see any special circumstance in the present case that will compel me to exercise my discretion in favor of the applicant by granting the present application. As a result, it is my firm decision that this application is lacking in substance and in merit. The same is hereby refused and is accordingly dismissed.
My Lord, we are very, very grateful, my Lord. I don't know if my Lord can hear me.
Yes, I can hear you.
Okay, thank you, my Lord. We are very grateful for the very erudite ruling of my Lord. May we most humbly, of all, apply for cost, my Lord. We apply for.
I shall not grant. I'm sorry, I didn't put that part of my ruling. No others to cost, please.
As court pleases, since my Lord didn't put it, because we should, because court follow events, my Lord.
Yes, I do know that.
As court
no
pleases.
Award as to cost, please.
As court pleases. But my Lord, may we only apply for a day hearing? We have only one witness, my Lord.
Yeah, but you know the court is going on vacation. So very well. I will not be able to hear it until after the vacation.
Yes, my Lord.
The 19th of October.
19th of October, my Lord. It's convenient,
Yeah, thank
my
you.
lord, to the claimant.
Court
Thank you very
case is
much, my
adjourned to
lord.
the 19th of October 2022 for hearing. Hearing
As
notices
court,
shall be issued and served
as
on
court, please.
the defendants.
As court pleases, my lord. We are very grateful, my lord.
Yes, the next case.
Yes.
Let's see.
NICN/KD/44/2018 between Tanko Adamu and 19 others. And one, L&C unit, Limited is saying International Limited. Two, Mr. Chen, TK. And three, Mr. Chen, Yuli. My lord, claimant present, defendant absent.
Yes, appearances.
May I please, my lord? ATU
Yes.
are my initials.
Yes.
Ibinola Mrs. My appearance, my lord, is for the claimant, for all the claimants. I'm most obliged, my lord.
Yes.
Respectfully, Lord, PG Serki, my humble appearance is for the defendants.
Thank you. Judgments. The claimants commenced the instant action via the complaints and statement of facts filed on the 18th of January 2018, wherein they claimed against the defendants the relief set out as follows. The reliefs is as stated on the face of the judgment, 5 reliefs thereof. To save the time of the courts, I've skipped it. You can view it on the face of the judgment. As claimed from the statement of facts, the claimants alleged that the defendants refused to pay their respective salaries and entitlements, and the several efforts they made to recover the said salaries and entitlements had proved abortive, thereby causing them severe hardship and subjecting them to inhuman and degrading treatment. The defendants joined issues with the claimants by the joint statement of defense filed on the 20th of April 2018. Essentially, the defendant's defense is that the claimants voluntarily determined their employment by their refusal to report to work and by instituting a criminal action against the defendants at the customary courts, Makera, Kakuri, Kaduna State. The defendants maintained that the salaries and entitlements of the claimants as agreed have been paid until they stopped work. The defendants further contended that the claimant's case is frivolous, and by way of counterclaim sought the relief set out as follows. 2 reliefs therewith, I'll skip it to you. The claimant's reply to the defendant's statement of defense was filed on the 7th of May, 2018. At the plenary trial, the 13th claimant, Festus Adejo, testified in person and on behalf of other claimants. He adopted his witness deposition on oath and tendered 20 documents in evidence as exhibits to support his case, to support the claimant's case. The case of the claimants was closed after being cross-examined by the learned defendant's counsel. The defendants called 3 witnesses, namely Peter Bayeri, Shegun Adedamola, and Andrew Kura. They adopted their respective written depositions as their evidence in chief and tendered 1 set of documents in evidence. They were also cross-examined by learned counsel for the claimants. At the conclusion of plenary trial, parties filed and exchanged their written final addresses as prescribed by the provisions of Order 45 of the rules of this court. In the final address filed on behalf of the defendants, deemed properly filed on the 10th of November 2021, PG Saki, Esquire of counsel, formulated a sole issue for determination in the suit as follows. Quote, whether the claimants have reasonable cause of action as to entitle them with all the reliefs sought in their statement of claim. The written address of learned counsel for the claimants, ATU Ibilola Esquire, was filed on the 3rd of December 2021, wherein issue 1 as raised by the defendant was adopted, and another issue was further framed as having arisen for determination in the suit. The issues are: 1, whether the claimants have reasonable cause of action as to entitle them with all the relief sought in their statement of claim, and 2, between the claimants and defendants who have proved their claims before this honorable court to be entitled to judgment in their favor. The defendant's reply to the claimant's final address was filed on the 23rd of December 2021. In the light of the reliefs claimed by the claimants, the evidence adduced by both parties on record, and the field of disputes between the parties, it is my view that the focal issues that have arisen for determination in the suit without prejudice to the issues already formulated by learned counsel on either side can be succinctly framed as follows. 1, whether or not the claimants have established by credible evidence their entitlements to the declaratory reliefs and other reliefs claimed in this action against the defendants in the suit. 2, whether the defendants' counterclaimants' claim are not liable to be dismissed. In proceedings to determine those issues, I state that I had carefully considered and taken due benefits of the written and oral final arguments canvassed by respective learned counsel to support their respective claims and the defense, as the case may be. And I shall, to that extent, endeavor to make specific reference to their submissions as I consider needful in the course of this judgment. I shall state from the outset that after a critical examination of the totality of the evidence adduced and documents tendered by parties on both sides, the court in this judgment has devoted attention only to issues considered materially in disputes between the parties in the suit and ignored matters considered not crucially relevant to the determination of the main dispute in the suit. This is in line with the position of the law that in that determination of a suit before it, a court is duty bound to consider material evidence adduced on real issues in controversy between the parties and is entitled to ignore irrelevant evidence adduced on issues not joined by parties. See the case of Ajao versus Alao, Adebanjo versus Brown, Spako versus Alrain, and Ajomie versus Nwakama, and other citations also applied. I am also not unmindful that the claimants have sought declaratory reliefs in the suit, the implication being that the burden for them to prove the allegation leveled against the defendants exceeds the regular burden provided in sections 131 and 132 of the Evidence Act 2011. The burden of proof on the claimant in establishing a declaratory relief to the satisfaction of the court is somewhat heavy, in the sense that such relief is not granted even on the admission of the defendant, as the claimants must lead credible evidence in proof of the declaration of rights is seeks from the courts. See the authorities of Dumes, Nigeria Limited versus Nwakogwa, Ogolo versus Ogolo, Olambanje versus Omakwen, citations all supplied. From the evidence on records, parties seem to be added that the claimants were employed by the defendants based on various agreements dated the 15th of June 2010, signed by the respective claimants and the first defendant. The terms of agreement and identity cards of some of the claimants were respectively admitted in evidence as Exhibit C1 to C1D and Exhibit C2 to C2F. The contention of the claimants, however, is that after working for a while, the defendants, in breach of the terms of agreement, stopped the payment of their salaries and entitlements, that upon inquiries from the defendants for the reason for the non-payment of their salaries and entitlements, the defendants merely apologized and assured them that the outstanding salaries and entitlements will be offset, but that the defendants have refused to make the payments in spite of the assurance. Excuse me. The claimants averred that as a result of the defendant's action, they engaged a solicitor and a direct criminal complaint was issued against the defendants at the customary court in Makare, Kaduna State, in suit number CCM/DC/1392164/12, in Tanko Adamu and 25 others versus LNU International Limited versus Saying International Limited, that after a series of legal actions at the High Court of Kaduna State, Court of Appeal Kaduna State Multi-Door Court, and Customary Court, the case was finally instituted at this honorable court. The certified true copies of rulings of the Customary Court, High Court of Kaduna State, and the Court of Appeal Kaduna Division were admitted as Exhibit C3 to C3B. The claimants alleged that they had suffered loss, hardship, damages, and lack of sustenance by reason of the defendant's refusal to pay their salaries and entitlements. The schedule of the claims, the claimants is admitted as Exhibit C5. The defense put forward by the witnesses of the defendants as it is material to the issues on the resolution is that the claimants were employees of the defendants from June 2010 until 2012, when they voluntarily determined their employment by their refusal to report for work and the filing of a criminal action against the defendants in the customary court, that the defendants kept a register of attendance of work for the period the claimants reported for work, that the claimants were paid by the defendants for the period they worked, as evidenced by their various signatures appended against the dates their salaries were collected on the payment schedule. The schedule of payments of the claimants with their signatures is admitted in evidence as Exhibit D1. The defendant's witnesses, DW2 and DW3, further testified that they are co-workers with the claimants, but the claimants had stopped coming to work since January 2013. The defendants further contend that they expended money defending the criminal action filed by the claimants and urged the court to dismiss the present case as same is frivolous and vexatious. The defendants also urged the court to grant their claims in the counterclaim. Excuse me. In the claimant's reply to the statement of defense, the contend that the defendant stops them from work after the criminal action was instituted against them, and that they did not voluntarily stop work as alleged. On the basis of the foregoing, therefore, the focal controversy between the parties is clearly understood, being the allegation of non-payment of salaries, gratuity, and other entitlements made by the claimants against the defendants. The pertinent question now is, have the claimants proved by credible evidence their entitlements to their claims? Exhibit C1 to C1D are the terms of agreement between the parties. In view of its relevance to the determination of this case, I find it necessary to refer to the terms of the agreement as conveyed in Exhibit C1, which is basically similar to terms as stated in Exhibit C1 to C1A. I have reproduced same herein under as follows. It starts with the title, Workers' Payment Analysis. Paragraph 1 states, you have been employed under the above mentioned company as a worker and therefore placed on a daily pay of 400 naira per day to be paid at the end of every month at 12,000 naira. 2, the company will pay you for the 4 Sundays of every month, even though they are work-free days. You shall be paid double if you work on Sundays and public holidays. You shall get annual leave of 7 days yearly with pay. And 4, every 5-year attracts 5 months salary as your gratuity. You will only be entitled to yearly bonus if you have worked above 3 months. There will be yearly increments of 10% of your salary. And 7, if you cease to work with a company for a certain period of time for any reason and wishes to come back, you may be reemployed as a new worker. The argument of Landed Claimants Council is that the claimant's case is hinged on the breach of paragraphs 2, 3, and 5 of Exhibit C1 by the defendants, and that all efforts made by the claimants for the payment of their entitlements have proved abortive. On his part, Learned Counsel for the defendants admitted that the claimants have not disclosed any reasonable cause of action against the defendants. With reference to the terms of agreement between the parties, Learned Counsel admitted further that the evidence as established by parties is that the claimants were employed between the months of June 2010 and December 2012, that by the terms of agreement, the claimants as employees are entitled to gratuity when they have served for 5 years, but that the claimants served for only 2 years and 6 months before they voluntarily determined their employment by their refusal to come to work. Learned Counsel submitted further that the testimony of the claimant's sole witness under cross-examination further established that the claimants were paid their salaries till December 2012. To buttress his submissions, Learned Counsel cited the cases of Umamba versus Nigeria Mining Company Corporation and Nwosu versus APP, citations supplied. Now, the terms of agreement in Exhibit C1 reproduced above is clear. As stated in paragraph 2 and 4 thereof, to be entitled to double pay for working on Sundays or for gratuity, the claimants must have worked on such a Sunday or must have respectively served for 5 years with the defendants. The claimants have not proved by any shred of evidence that they satisfy the requirements to be entitled to these allowances. That is, for the double pay on Sunday and for gratuity. While admitting paragraph 1 of the statement of facts, the defendants have heard in paragraph 1 of the statement of defense that the claimants were their employees between June 2010 and until 2012, when they voluntarily determined their employment. The claimants, in their reply, merely stated that the reason the claimants stopped coming to work was that they were stopped by the defendants, but they did not deny that they stopped work in 2012. CW1, while answering questions under cross-examination, further established that the claimant stopped work in 2012 when it testified as follows. I quote, "There was no time I worked for the defendants and I was not paid. Yes, I worked throughout the duration of 2010, 2011, and 2012. It is true that I was paid up till December 2012. I have not worked from 2013 till date. I do not know if the other claimants worked for this period, that is from 2013 till date." End of quote. Now, it is a settled position of law with statutory backing and legion of decided authorities that what is admitted needs no further proof. By Section 123 of the Evidence Act 2011, No facts needs to be proved in any civil proceedings which the parties to the proceedings or their agents agreed to admit at the hearing, or which before the hearing was agreed to admit by any writing under their hands, or which by any rule or pleading in force at the time they are deemed to have been admitted by their pleadings, provided that the court may in its discretion require the facts admitted to be proved otherwise than by such admission. By this provision, generally in civil proceedings, unless a court deems it fit, as provided for in the proviso to call for further evidence, what is admitted requires no further proof other than such admission. There are too many cases in this principle. See Akinlagun versus Oshobaja, 2006, 12 Nigeria Weekly Law Reports, Part 993 at page 60. CW1 admission under cross-examination that he had been paid by the defendants for the work done and that he had been paid till December 2012 needs no further proof. And I so hold. The further argument of learned layman's counsel is that the amounts being claimed is itemized in Exhibit C5. In the second exhibit, the claimants claim are itemized as salaries, 7 days for 3 years, 3 years gratuity, 1 year bonus, and 10% of salary. Those claims, as reflected in Exhibit C5, were categorically denied by DW1 and further tendered Exhibit C1, the register of payments endorsed by the claimant's signatures to buttress the defense. While answering questions under cross-examination by the claimant's counsel, DW1 testified as follows, I quote, "The calculation in Exhibit C5 is not the calculation as reflected in Exhibit C1, and it is not correct. The defendants did not terminate any of the claimant's appointments. The claimant stopped work voluntarily. It is true that we did not pay them for the work they did not do. We paid all that was due to them." At this juncture, I should restate the tribe's position of law that a claim is circumscribed by the relief's claims. And the duty of a claimant is to plead cogent facts and materials as are necessary to sustain the reliefs and adduce evidence to prove same. See Gabriel Atif versus Cabell Metal Nigeria Limited, 2008, 10 Nigeria Weekly Law Reports, Part 1095. In paragraph 18, sub C of the statements of facts, the claimant's claim is for, I quote, an order directing the defendants to pay the claimants their respective salaries and entitlements in the sum of 1,755,299 naira only, as shown in the breakdown. There is no breakdown or calculation of the claims in the claimant's statements of fact. Learned Defendants Counsel had argued that Exhibit C, upon which the claimants hinged their claims, did not emanate from the defendants. I have also undertaken a review of Exhibit C5. The document is undated and unsigned. Consequently, it is fraught with doubt as to whether it was not a cooked document merely made solely for the present case. The law is settled that an unsigned document is a worthless paper. It is inadmissible, and where admitted, it cannot be relied upon by the courts to resolve any controversy between the parties, as no weight or probative value can be attached to an unsigned document. See the cases of Aniese versus Ianso, Union Bank Limited versus Toibo, citation supplied. Such a document as Exhibit C5, unsigned as it was, is incapable of establishing the claimant's claims against the defendants. And I so hold.
As a court, please.
It has been held in several decisions of this court that an employee making a claim in an employment of labor case has the burden of proving his entitlements to the claim and the quantum of the sums claimed. To prove the quantum of the sums claimed, the rule regarding proof of special damages must be adhered to. This is because the claims for entitlements and or benefits, being monetary sums, is a claim for special damages. See Anyanwu and others versus Uwasoke and others. 7-Up Bottling Company Limited versus Augustus, citation supplied. In other words, the claimants are duty bound to give specific particulars of the special damages being claimed. This is the context within which the claimants can succeed in the present case. Having admitted that the defendant had paid all their salaries up till December 2012, and having failed to give specific particulars of special damages being claimed or the amounts being claimed, as Exhibit C5, which they relied on, has been rejected, or as Exhibit C5, which they relied, has been rejected by the court, the claimants have failed to establish their claims against the defendants. And I so hold. Issue 1 is resolved against the claimants. I so further hold. In totality, the conclusion of the court is that the claimants have failed to lead credible evidence in support of the reliefs claims against the defendants in this action. Accordingly, it is the judgment of this court that the claimant's claim is unmeritorious. It shall be, and it is hereby dismissed.
As a court pleases.
My Lord,
the defendants filed a cancer claim for the sum of 2 million naira as damages for the injury that the claimants have made them to suffer for defending the various cases. It is settled that a cancer claim is for all intents and purposes a separate, independent, and distinct action, and the cancer claimants, like all claimants in the main actions, must prove his cancer claim with credible and convincing evidence to obtain judgment. It is also tried the facts not proved on the preponderance of evidence is of no avail to that party. The cancer claimants did not prove by any documents their claims in the court. As such, the cancer claimants' relief for damages is clearly unfounded and is accordingly dismissed. Without further ado, the defendant's cancer claim fails in its entirety. I so further hold, in the final analysis, the claimant's claim and the defendant's cancer claim lack merit and substance and are hereby accordingly dismissed. Parties shall bear their respective costs.
As a court pleases.
As a court pleases.
Yes, this is the judgment of the court.
My Lord, we are most obliged for that very considered judgment. We are most obliged.
Thank you.
My Lord, we are grateful for a well-articulated judgment.
Yeah, thank you. Yeah, I hope to send the copy of the judgments today, so you can apply for it as from tomorrow, probably by midday tomorrow, please.
As a court, please.
We are most obliged, my Lord.
We're grateful.
Thank you. The courts will rise.
I love this.